Good morning, Your Honors.
Good morning.
Martinez Jackson on behalf of appellant. I would like to introduce my co-counsel, Jamar Creech, is an attorney barred in the state of Maryland. His pro hoc vici application has already been accepted by the court.
His application, your application to accept him is granted.
Thank you, Your Honor.
I will spare you the speech of our colleague, Judge Mazzarelli, that we have over 100,000 very fine lawyers in New York, but welcome to our abode. You may proceed.
Thank you, Your Honor. May it please the court. As my co-counsel said, Jamar Creech on behalf of the appellant, Dagoberto Velez. Your Honor, Dagoberto Velez was not just a talent scout for the Ultimate Rap League. Point of origin is very important in this case. As the record shows at page 13, plaintiff was approached in 2009 to be a partner with the Ultimate Rap League, with the respondents approaching him to do so. The record also says, on or about October 26, 2009, Ultimate Rap League began its operations in New York as a general partnership. Now, what happened here was the company started to grow and to grow and to grow. And
Counsel, let me interrupt you. Where does the amended complaint speak of the sharing of losses in the partnership? What chapter and verse, you know?
Oops, strike one.
Certainly, Your Honor. With respect to the sharing of profits and losses,
And specifically with an eye towards why the added statements are conclusory and insufficient.
so the complaint at, one moment.
And we're using the amended complaint, correct?
Yes, the amended
Right.
complaint.
Why are the allegations that were added there insufficient as conclusory?
Your Honor, that's, we disagree with the court because in 2019 alone, Mr. Velez put in $50,000 worth of capital contributions to host events on behalf of the Ultimate Rap League. And there's nothing in the record that says he even got that back. So the court
Sir,
said,
is a contribution analogous to a loss?
Whoops, strike three.
not necessarily, Your Honor. I would say a contribution's capital, but it can lead to a loss if that is not, if that investment is not returned, you know, at least at that amount or greater, which would be a profit.
So I have to say that looking at the briefs and going through the record, this appears to be a very sad situation, to say the least. But we not only have what's purported to be an oral partnership agreement, but as my colleagues say, there appears to be no indication that there was an agreement that Mr. Velez would also share in the losses if the partnership took a hit.
Strike three, and he's out.
And that's the part that's missing. So if
And it seems to be undermined by other things your client says with respect to if they needed to raise capital, et cetera, et cetera. He goes on about that, which seems to suggest that there wasn't real formality with respect to these essential elements of a partnership.
Well, Your Honor, as general partnerships go, I think that there may be instances where there isn't necessarily formality. I think that's...
Yeah, but, right, there's no formality, there's no written contract.
Absolutely.
That's an example, right? But you and I agree to do something and say, all right, we're gonna share in the profits, but we're also gonna share in the losses, okay? Is there any allegation here that that was the agreement between these parties, that that was stated clearly, and that that was the understanding that they were operating under?
Well, I think the inference that can be drawn from the complaint, and that's.
You were here when we were talking
I
about
understand.
inferences
I-
earlier.
I understand, Your Honor. And just liberally construing the complaint, the expenses that Mr. Velez paid for on behalf of the Ultimate Rap League were central to their operation. So it wasn't.
But again, that's capital. That's not losses.
Right, and you're absolutely correct, Your Honor. I guess what I'm saying is that in order for us to even get to the point of establishing what losses were, we would need to go through the discovery process, and we're being cut off here because.
But why wouldn't if there were losses to the partnership that were shared by all the partners, we don't need discovery. Your client should know what those losses are.
I think that's.
Unless he wasn't truly a partner and wasn't privy to all the goings-on of the business.
I see my time is up, Your Honor, so I'll take my seat.